All right, if you've got your evidence law exam coming up, you are in exactly the right place. Today, we are going to take a deep dive into the history that created the Indian Evidence Act of 1872. And trust me, understanding where this act came from is absolutely essential to mastering how it works. Okay, so here's our game plan. We're going to trace this whole story from the very beginning. We'll start with ancient Hindu systems, see how things changed under Muslim rule, then get into the chaos that came with the British. After that, we'll look at the first attempts to fix things, the final codification of the act you study today, and even some of the big debates that are still going on. First up, let's travel way back in time. We're going to explore the system of evidence in ancient India. And it's easy to think of ancient law as simple or primitive, but what we find here is this incredibly sophisticated framework that was tied directly into the philosophy and the entire social order of the time.
Now, to get any of this, you first have to understand the concept of dharma. It wasn't just law in our modern sense. It was everything. It was religion, duty, morality, and justice all rolled into one. So, for a witness telling the truth wasn't just a legal rule, it was a profound religious duty. Even the king had to answer to dharma. It was the ultimate bedrock of their entire legal world.
And look at this, the structure of their judicial process. If these 4 stages look a little familiar, they should. You've got the initial complaint, the reply from the other side, the trial, where everyone presents their evidence, and then the final judgment. This is basically the blueprint for a modern lawsuit. This shows it wasn't some random haphazard process. It was logical and really well organized. Now this is where it gets really fascinating. Check out these ancient rules on the burden of proof. The Dharmasastras laid out principles that are, fundamentally the same as what we use today. The person who makes the claim has to prove it. If the defendant admits something but adds a twist, like, yes, I took the loan but I paid it back, well then the burden shifts to them to prove they paid it back. These are core concepts you'll see over and over again. And they were also way ahead of their time on something we still wrestle with, the danger of relying only on circumstantial evidence. The story of the sage Ani Mandavya is the perfect example. Picture this. He's sitting there meditating when some thieves run past and dump their stolen goods in his hut. The king's guards show up, find the stuff, and just assume he's the thief. Based on nothing else, he was convicted. This story became this powerful cautionary tale, a lesson that you can't just jump to conclusions. You have to investigate properly.
Okay, so now the scene changes completely. With the arrival of Muslim rule in India, a whole new legal philosophy comes into play, based on Islamic law. And it didn't just wipe the slate clean. It interacted with the Hindu practices that were already there, creating this new, complex layer in India's legal history.
And one of the biggest, most immediate changes was the total rejection of trial by ordeal. Hindu law had things like trial by fire or water as a way of getting divine proof. Strict Islamic law, on the other hand, said absolutely not. This was a really significant shift away from what we'd call superstitious practices toward evidence that humans could actually evaluate.
And here's a classic example of Islamic law in action, a super high, incredibly specific burden of proof for certain crimes. Take adultery. The punishment could be extremely severe, so to get a conviction, the law required nothing less than 4 male eyewitnesses who saw the actual act itself. Think about how high that bar is. So where did this incredibly strict rule even come from? Well, the historian Gibbon connects it to a very personal story about the prophet's wife, Aisha. She was falsely accused and a divine revelation came down to clear her name. Right after that, the law was established really to protect women from exactly that kind of false accusation by setting this almost impossible evidentiary standard. Now, this doesn't mean they threw out circumstantial evidence entirely. They called it karina. And it was allowed, but only if it was pretty much conclusive. There's this great case where a scribe's wife was accused of being an imposter. The judge, to test her, just asked her to fill an ink pot. She did it with such an expert, practiced hand that he was convinced she was the real deal. It's a perfect example of using strong circumstantial proof. All right, now we hit the period of the British and the East India Company. And honestly, this is where things just get chaotic. You've got English common law, Islamic criminal law, and Hindu personal laws all crashing into each other all at once. It created this period of massive legal confusion. And this slide just lays out the problem perfectly. You had 2 completely different legal worlds. In the big presidency towns like Calcutta, English law was king. But the second you stepped outside those cities into the vast countryside, the Mufassal, it was a total free-for-all. Islamic law for crimes,
personal laws for family matters, and for anything that didn't fit, judges were just told to decide based on justice, equity, and good conscience. I mean, what does that even mean? It was completely unpredictable and created a desperate need for one uniform set of rules.
So, obviously, that kind of chaos just couldn't last. It directly pushed the British to start trying to create a single, uniform law of evidence that would apply everywhere. They started passing a series of acts, slowly but surely, trying to clean up the mess and build a coherent system from the ground up.
And you can see how they started to build it piece by piece. Starting in 1835, they began getting rid of old, outdated rules. For instance, they said that just because someone had a conviction, it didn't mean they couldn't be a witness. Then they said the parties in the case could actually testify. But the really big jump was Act 2 of 1855. It introduced concepts you'll recognize, like judicial notice and dying declarations, slowly layering English legal principles onto the Indian system.
But all these little fixes were just leading to one big goal, a single, all-encompassing code of evidence. But, their first try at it? It was a total flop. But that failure was actually super important because it opened the door for the person who would finally get it right. The first draft, back in 1868, got torn apart by critics. They said it was a mess, badly organized, way too complicated, and basically unusable unless you were already an expert in English law. It just wasn't practical for the judges and officers in India who needed a clear, simple guide.
So they needed a new plan. And in comes Sir James Fitzjames Stephen. He essentially threw out the old draft and started fresh, and what he created became the Indian Evidence Act of 1872. It was immediately hailed as a brilliant compromise. Why? Because it took the logic of English law but made it practical, systematic, and easy to understand for the Indian legal system. It's his work that you're studying today.
But the story doesn't just stop in 1872 with the act being passed. Nope. For your exams, you have to know about the big, juicy controversies baked right into the act itself, debates that have been going on in courtrooms for over 150 years. Let's look at two of the most important ones.
First, there's the famous Section 11 on the relevancy of facts. It says a fact can become relevant if it makes the main issue highly probable or improbable. Okay, sounds simple, right? But the debate is, what does highly probable actually mean? Is this a wide-open gateway for lawyers to bring in all sorts of evidence? Or is it a much narrower door? That ambiguity has kept lawyers and judges busy for a very long time.
And then we have the big one, the Section 27 controversy. This section is an exception. It says if an accused person makes a confession to the police that leads to the discovery of a fact, that part of the confession can be used in court. But here's the kicker. It only applies if the person is in police custody. This raises a huge fairness question. Why should it matter if they were in custody or not? It seems to create this totally arbitrary distinction. So how do we solve this puzzle? Well, there's a really elegant interpretation that you need to know. The argument goes like this. Look at the sections together. Section 25 is the big general rule. No confessions to police, period. Section 26 is more specific. No confessions while in custody. The key argument is that Section 27 isn't an exception to the big rule in 25. It's actually a tiny little exception, a proviso, that applies only to Section 26. If you read it that way, the whole contradiction and the fairness problem, well, it pretty much disappears.
All right, so let's pull it all together. What have we learned? We've seen that India's evidence law has incredibly deep and sophisticated roots. We've seen modern ideas in both ancient Hindu and Muslim law. The 1872 Act wasn't created in a vacuum. It was the direct solution to the legal mess of the British era. Sir James Stephen's code was built to last, but key parts of it, especially sections 11 and 27, are still being debated in courtrooms right now. And that leaves us with one final big question to think about. We've tracked this law's evolution from ancient Dharma all the way to a code designed for the 19th century. It was a masterpiece for its time, no doubt. But as you get ready for your own careers, the real question is this. Is a law written before the telephone, let alone the internet, deepfakes, and AI, still ready for the challenges of our world today? That's a question you all will help answer.